As one of the main knowledge centers in the world, our concern is to always be an innovative institution, both for our students and for society as a whole. The webinars offered daily by the schools and units of FGV are a way to promote the exchange of knowledge in diverse areas about relevant and current subjects, information, research, plurality of ideas, high-level debate. All of this happening for free, online, and daily. Welcome to one more FGV webinar. The broadcast will start soon. The statements expressed by Fundação Getulio Vargas employees and guests who take part in online events and broadcasts exclusively represent their opinions and not necessarily FGV's institutional position.
Good morning, everyone. A warm welcome to everyone from our panel, our panelists, the attendees. It's with great pleasure we start today our fourth day of our fourth Sino-Brazilian and China dialogue, Belt and Road in Brazil, rules and coordination. I have to read the disclaimer before for everyone from FGV that followed. The statements expressed by Fundação Getulio Vargas employees and guests who take part in online events and broadcasts exclusively represent their opinions and not necessarily FGV's institutional position. We also reiterate that everyone present here spontaneously agreed to participate in this event and to authorize the use of their name, voice, and image, besides assigning the copyrights related to their exhibition for this broadcast, which will be available later on FGV's official channels. To continue with this transmission, we ask you to verbally express or sign your agreement with this. We just ask you to thumbs up. Everyone, thank you very much. Professor Carey is there. Okay, all right, now we can start our panel. Today, we discuss trade and dispute resolutions, rules, perspectives, and intercultural challenges. A warm welcome for our panelists, Mr. Li Hu, Vice Chairman of China Maritime Arbitration Commission, Professor Carey Shang from California State Polytechnic University, Ms. Natalia Lamas, lawyer of FCDG Law Offices, Leonardo de Campos Melo, lawyer, arbitrator, Natalia is arbitrator as well, Leonardo de Campos Melo, arbitrator in founding associate partner of LDCM lawyers. So we prepared 4 points to cover today on this subject, trade and dispute resolution. The first one will be the connection between Belt and Road and dispute resolutions in China and Brazil. We try to understand a little bit more how it works and how it's interconnected with our country and with China. The second one is the choice of applicable law and predicability under Brazil and Chinese arbitration laws. The third one is cultural challenges, always a big issue between two countries and especially between China and Brazil. We discussed nationality of arbitrators, mediators, language, translation. And the fourth point will be enforceability of the arbitral award in China and Brazil. In international arbitrations, we always know that we have a word, of course, and after the enforceability could be a problem or something we have to figure out before going to enforce this award in our country or in a foreign country. We don't have a speech from each one. We try to share their thoughts, starting with one and after changing the comments for the second and third and fourth one, and we will change that again for the next point. The third point, the first point will be that we face today the connection between Belt and Road and dispute resolution in China and Brazil. And we like to start with Mr. Li Hu, followed by Carrie Shang, and the comments will be held by Natalia and Leo. Please, Mr. Li Hu.
Thank you, moderator. I'm very happy to join today's webinar organized by FGV. With many thanks to the kind invitation of FGV School of Law. Actually, the One Belt, One Road initiative, we know that originally we refer to the 65 countries alongside Asian Silk Road. But now the Belt and the Road initiative is open to all countries. By the end of last year, China has signed BOR cooperation documents with 138 countries and 31 international organizations. So under the Belt and Road initiative, in the Chinese mainland, the relevant policies, laws, and regulations have been issued and enacted to attract foreign investments and encourage Chinese companies and enterprises to make overseas investments and trade. So we can see this phenomenon in the field of dispute resolution. In the past 5 years, arbitration in China, Asia is developing. So in China, there are totally 270 arbitration institutions. Among those institutions, China International Economic and Trade Arbitration Commission and the China Maritime Arbitration Commission, with which I'm working with, are the two oldest ones. To CTAP, the founded in 1956 and CMAC 1959. So up to now, in China mainland, most of the foreign-related disputes are still submitted to CTAP and CMAC for arbitration. According to my statistics, in the past 5 years, from 2016 to 2020, both CTAC and CMAC accepted 36 cases 36 cases where one of the parties is from Latin American countries, 5 from Mexico, 8 from Brazil, 3 from Peru, 6 from Panama, 1 from Venezuela, 5 from Argentina, and 5 from Chile. So we can see the increase of the cases in connection with Latin American regions. CMAC, is only one national maritime arbitration institution in Chinese mainland, specializing in maritime and other commercial disputes by the means of arbitration and mediation. CMAC has accepted 354 cases, including 113 international ones since 2018. CMAC is a maritime arbitration institution. So last year we saw 111 new maritime cases with 29 international ones, where the parties from 22 countries regionally in the world. And quite a few cases in connection with the parties from Latin American countries. The first disputes arising from those contracts concluded outside Chinese mainland. It is not always the case that the parties will agree on arbitral seat of the Chinese mainland. It is likely that the parties choose a third and neutral seat. In the past few years, we can see more and more international arbitration institutions to accept more and more China-related disputes. For example, SEC, for example, Singapore International Arbitration Center and Hong Kong International Arbitration Center. Each of these institutions accepts more than 70 China-related disputes. So this also can prove that the development of One Belt, One Road initiative. So I just want to give some comments briefly. Thank you.
Thank you very much, Mr. Liu. We could understand that we are growing a lot, of course, and we need to figure out more with Professor Carrie Schenk.
Thanks, Marcel. And I think Professor Liu has given us a very good overview of the entire Belt and Road initiative. He has given us some historical point of this strategic initiative that was initiated by China's current President Xi Jinping to basically promote international commerce between China and various countries in Europe, in Southeast Asia, in Africa, as well as in Latin America. And it's also about to increase the kind of bilateral investment, but really to promote Chinese corporations, especially state-owned enterprises, to engage in more type of international investment, particularly infrastructure investment in those above-mentioned countries. So Professor Liu also mentioned that a lot of different subcontracts have been signed by China and those countries in different regions, even though Brazil hasn't been formally a part of the Belt and Road initiative in many different ways. It doesn't, or it shouldn't really impact the currently the very active trade and investment relationship between China and Brazil. Well know that China is basically one of the biggest trading partner, maybe the biggest trading partner of Brazil currently, and Brazil is also one of the very important, most important trading partner of China in the United States. I do have some data to share here that we see that even though we were just hit by a pandemic, the export from Brazil to China hit a new height of around 46.74 billion American dollars in March 2021. So there was some very recent data, and we see that the bilateral trade between the two countries have been caught up. There are some top products that were imported from Brazil to China during this period, including a lot of raw materials, but also agricultural products such as soy and beef. very popular Brazilian products. And China has also been exporting a lot of different products, mainly technology-related products to Brazil, including telecommunications, equipment, somatic molds, tubes, transformation industry materials, and many others. So we see that even though there was just a pandemic, the bilateral China-Brazil trade hasn't been impacted very much. And China has still been very active in its investment in Brazil, mainly concentrating in energy industry, and also a couple of infrastructure projects in Brazil, but mainly concentrating in energy industry, as far as my data shows here. So as Professor Li also mentioned, because there are a lot of different commercial relationships between Brazilian parties and Chinese party, it shouldn't be surprising that we see an increasing number of disputes. Professor Li just mentioned data concerning CTEC, that is the organization he represents. Actually, also have a couple data from other institutions, such as ICC, which just a newly formed commission BRI, Belt and Road Initiative, and opened up its office in Sao Paulo. ICC is basically one of the most popular dispute resolution venue between Chinese and Brazilian parties outside China mainland. I also got some recent data from the Hong Kong International Arbitration Center, which administered 12 cases involving Latin America parties in the past 5 years. Majority of them took place during the past 3 years, covering countries including Brazil, Costa Rica, Guatemala, Honduras, Mexico, Panama, and Peru. So by sharing those, what I want to emphasize that is, first of all, Belt and Road Initiative is not a static mission, and it's keep changing all the time, subject to diplomatic relationship China is having, and also economic partnership China is choosing to have. And secondly, because those type of very prosperous economic relationship between Chinese and Brazilian parties, we're going to see an increased number of disputes in good and bad ways. So those are my kind of the 2 cents about the initiative and the dispute resolution status.
Very interesting, Carrie. You raised some statistics, and of course, China is the first partnership of Brazil in entrepreneurship. Now we change. Natalia, please.
Hi, good morning. First of all, thanks for the invitation. I'm really happy to be here. And hearing Professor Carrie Chang and Professor Li Hu speak about the Belt and Road Initiative and the expectation to have a growth, which we, as arbitration practitioners, really expect to happen, to have a growth on the disputes between Brazil and China. I was wondering, mainly due to Professor Li Hu's speech, which city would be a neutral seat on the perspective of a Chinese party? Because Brazilian parties are used to neutral seats related to Europe or New York, for example. It's usually Paris, London, or New York. But I believe we are open to have other neutral seats, maybe other Asian cities, which would probably make Chinese parties more comfortable. So I would like to hear if, for example, Singapore would be a neutral seat on the perspective of a Chinese party, if a Chinese party would feel comfortable to have Singapore as a neutral seat, or any other thoughts you, Professor Li, who may have on this.
Please feel free to comment.
So thank you, Natalia. You mentioned the seats of arbitration. Yes, under the BR initiative, the foreign-related arbitration channel has been developing rapidly in recent years, as mentioned by me just now. In my mind, in the next decades, the Chinese mainland is likely to be one of the preferred international arbitral seats, taking further into consideration that the foreign institutions are allowed to provide arbitration services in Chinese mainland. For example, Shanghai and Beijing had issued relevant policies to encourage foreign institutions to create offices in Shanghai and in Beijing. On the other hand, Belt and Road Initiative has also benefited international arbitration with approved mentioned by being that quite a few regional international institutions in Asia and Europe have accepted more and more Chinese-related disputes. To my best knowledge, besides Chinese mainland, the Chinese parties have preference or are likely to choose Hong Kong, SAR, Singapore, Paris, Stockholm, and London as a seat of the arbitration. On the flip side, the choices of the parties may be more diversified in the future. For example, alongside choosing CIMAC arbitration with a seat outside Chinese mainland, the parties may directly appoint the CIMAC Hong Kong Arbitration Center for arbitration with a seat within or outside the Hong Kong SAR. They will also agree with foreign institutions arbitrating in Chinese mainland, for example, the Brazilian arbitration institutions arbitration, but with seats in Chinese mainland. Or they may directly agree with the Brazilian arbitration institution for arbitration in Brazil. It depends on the negotiation of the parties. In my mind, the main cities in Brazil has the more and more competitive ability in the future for arbitration relating to Chinese parties, because with more and more investments and trade volume, increase of investment trade volume between China and Brazil. So I think we can see the future of the arbitration in the region, in Asia and in Latin America countries. Thank you.
Gary, anything to add?
I definitely agree with Professor Lee Hu of his points. I kind of want to add that, so I've been going over a couple of different disputes between Chinese and Brazilian parties over the past couple of years. I really see a very diverse choice of parties venues. There was one case that was actually taking place in CCPC, that's a Brazilian institution. Then we have a couple of ICC disputes. I just to mention that I do think that ICC remains one of the top choices between Brazilian parties and Chinese parties outside mainland China. ICC also has its office in Sao Paulo, New York. I do think that the United States has potential of offering a couple of different seats and the auspices of some of its most popular arbitration institutions, such as SCDC, which has an office in Miami, that offers a very convenient location for parties of either Brazilian and Chinese regions. And also, as Professor Lee Hu mentioned, Hong Kong and Singapore remains popular to Chinese parties. I think I'm also participating in one dispute involving Brazilian parties that were taking place in the Shanghai International Arbitration Center. So it's really diverse choice of parties, which is good from the perspectives of neutrality to parties and also for the business of arbitral institutions.
Well, now Leo would like to hear your thoughts.
Good morning, everyone. First of all, I would like to thank Professor Evandro Carvalho and the Getulio Vargas Foundation for the kind invitation to be on this panel today. Also, Professor Marcio Guimarães, and as well, I'd like to thank and say hello to my fellow panelists, Professor Carrie Chang and Mr. Lee Hu. I was wondering, hearing Mr. Lee Hu and Mrs. Carrie Chang's presentation, what would be the relationship of the recently created China International Commercial Courts in support of arbitration in what concerns disputes related to the Belt and Road Initiative? Is there a track record of relation between these courts and international arbitration in China? And if so, what would that be? I'm very curious to know that.
So thank you for the question. Yes, you know, in order to formulate a flexible EDR mechanism and better serve the One Belt One Road initiative, Supreme Court of China (SPC) has established 2 Chinese International Commercial Courts (CICC) in Shenzhen of Guangdong Province and Xi'an Shanxi Province, respectively, and 1 International Council for Commercial Experts (SCCE). The CICC, you know, play an important role in creating a uniform platform for ADR approach to resolve BOR disputes. For example, according to the CICC rules of procedure, which has come into force since 5th December 2018, SPC has formulated the panel of arbitration mediation institutions and includes CMAC, CTAC, and other 3 Chinese arbitration institutions and 2 mediation institutions into the panel, so that, you know, for the relevant international arbitrations in connection with the disputes related to One Belt One Road initiative, or disputes arising from the related countries' regions. For such international arbitrations conducted by CMAC, the parties may enjoy direct support from SPC for conforming jurisdiction, for granting interim measures in the arbitration proceedings, and enforcing the final word. I mean, for the international arbitrations conducted by CMAC, after the word has been made, if one of the parties applies for enforcement of such a word, that party can apply to SPC directly for enforcement. It's not necessary for the party to apply to the other courts in accordance with the ordinary provisions of law. So that's different. And SPC, by establishing the CICC, and can provide better services for disputes concerning One Belt One Road initiative. So thank you. One point I want to mention that for one International Council for Commercial Experts, SCCE, the council member of the SCCE may be appointed by SPC to provide mediation services for disputes as agreed by the parties to have the disputes to be mediated by the council members. So the settlement agreement reached by the parties in mediation by the council members can be directly confirmed by the SPC and transform the settlement agreement of parties into the SPC court decision so that the decision can be enforced directly. So that's also the advantage provided by CICC. Thank you.
Welcome. It's very interesting, your explanation, because Mr. Li Hu, I read an interview you gave to ICC some years ago, I think it's 2019, and you stated that, I wrote here, the general principle is that harmony is most precious in China. So I think it's important to understand, especially for us in Brazil, that you avoid, at least to the end of the dispute, you avoid an award. You always trying to settle, and in your law, I know on the Chinese law, the settlement could be reached any time during the proceeding, the arbitral proceeding, and will be ratified for the arbitral tribunal instantly. That's very interesting. So we can move on to our next And second point, there will be choice of applicable law and predicability on the Brazilian and Chinese arbitration laws. We figure out here choice of law, liberty on the Brazilian and Chinese arbitration law, if there are some or any exceptions, if yes, like public entities, state-owned companies, an overview about it. We start with Natalia, followed by Leo, and after the comments from Lihu and Carrie Shang. Please, Natalia.
So since our law from 96, we have liberty, full party autonomy to choose the choice applicable to the merits, which is very good because at that point, we didn't have such party autonomy in Brazilian courts. So arbitration became a sure way to deal with an international dispute because the parties were sure to be free to choose an international law if they want, or any other law for the sake of the matter. So this is in Article 2nd of the Brazilian arbitration law. Regarding exceptions and public entities, I think it's interesting to see, to make a step backwards, just to put everybody in the same level. Today, Brazilian public entities are allowed to arbitrate their disputes. There is no more any controversy on this issue because the Brazilian arbitration law has been changed in 2015, allowing that. Before such change, we didn't have any express authorization in the Brazilian arbitration law from 96, the original one without the changes from 2015. But we had several other laws, sectorial laws, for example, the oil and gas law, or the telecommunications law, or the concessions and public permits law, that had articles, legal dispositions allowing public entities to go to arbitration. Right now, after 2015, we are sure that there is no longer this discussion, as the general law of arbitration has allowed this to happen. And regarding arbitration with Brazilian public entities or state-owned companies in general, we also had before 2015, and based on these various laws and on certain doctrinal and academic professors that held that this was always allowed because the arbitration law did not prohibit the public administration to go to arbitration. We had several case law mainly from the SCJ, the Superior Court of Justice, allowing several public entities to go to arbitration. So the question is there an issue with the choice of law that these public entities choose to go to arbitration? Are they bound to arbitrate under Brazilian law, or are they free to choose whichever law they believe suits better the contract? Well, as I said, before 2015, we didn't have a unique and general law over this matter. The Brazilian arbitration law did not regulate this matter. So we had several sectorial laws that allowed for arbitration by Brazilian public entities under using Brazilian law. So using Brazilian material law, the contract would be subject to Brazilian law. The law in 2015 did not provide for exclusively Brazilian law to be used by Brazilian state-owned entities or Brazilian public administration. Article 2nd, paragraph 3rd, provided for Brazilian public entities authorization to arbitrate their disputes under law. Point. So this means that Brazilian public entities cannot go to arbitration with an habeas compositeur or ex equi bono. Brazilian public entities have to submit their disputes to law arbitration, to an arbitration under a certain law. And after that, several discussions happened if this meant only Brazilian law or not. There are several authors that believe that Brazilian public entities can only be subject to Brazilian law, but there is an understanding that has been that several arbitration practitioners have stated and put forward in one jornada, which is a congress where arbitration practitioners discuss several rules and try to establish directions for interpretation of several rules of arbitration in Brazil. And in 2016, these Brazilian arbitration practitioners have stated that Brazilian public entities, well, this is not law, this is just soft law or guidance law. So these Brazilian practitioners have stated that Brazilian public entities may be subject to international soft law and usage of a certain area, for example, lex petrolia or lex mercatoria, which gives rise to a question whether, why not an international law itself? Why not a foreign law, that to be more precise? So I think Leo can talk a little bit more about these discussions on if there is really an exception on this choice of law liberty to Brazilian public entities, mainly after 2015. Thank you.
Sure, thank you, Natalia. So basically what Natalia is saying is that in 2015, we had the so-called good news that Brazil now accepted that the public administration could officially, under a general authorization of the Arbitration Act, could be part of arbitrations, encompassing the direct administration, be it the federal government, the states, the federal district, and the municipalities, as well as the so-called indirect administration, encompassing public-owned companies, independent agencies, semi-public companies, and public foundations. However, since 2015, I'm gonna be very objective on this issue. We had I would call a little setback on that, because at the federal level, we had in 2019 a decree signed by President Bolsonaro, which regulates the use of arbitration by federal administration involving contracts in the sectors of ports, roads, rail, airports, and waterways. And according to this decree, the federal government, when involved in arbitrations, the requirements as for choice of law and seat and language are the following, and mandatory. Arbitration must be decided by points of law. The law must necessarily be Brazilian law, and the seat must be in Brazil, and the language of the arbitration must be in Portuguese. The same rules were basically adopted by the state of Rio de Janeiro and the state of São Paulo and some other states, but I'll stick to these two states. They have issued their own state decrees regulating the use of arbitration by the direct and indirect administrations of the state of Rio de Janeiro and the state of São Paulo. And basically these two decrees say the same thing as the federal decree, meaning that all arbitrations involving the state of Rio de Janeiro and São Paulo, they must necessarily be decided by points of law, which is the Brazilian law. The seat must be in São Paulo and Rio de Janeiro, respectively, and the arbitration must be carried in Portuguese as well. So despite the general authorization in terms of choice of law of the 2015 amendments to the Brazilian Arbitration Act, some supervening regulations in Brazil at the federal level and state level have restricted the choice of law applicable to the arbitrations involving these entities.
Very interested to our panels comparing Brazilian and Chinese trade, because you have a lot of Chinese companies in Brazil that is investing in infrastructure. And you're investing in infrastructure, you always have a public company or the state involved. So I'd like to hear from Mr. Lihu, your comments.
Well, you know, in China, under Chinese legal framework, it's free in arbitration. It's free for the parties to choose the law applicable to the arbitration agreement. So the validity of the arbitration agreement shall be decided in accordance with the law chosen by the parties. In the absence agreement by the parties, it shall be decided under Chinese arbitration law. And for the substantive law, it's also the parties are free to choose law applicable to the substance of the commercial disputes. However, for joint venture disputes, it can only be resolved in accordance with the Chinese law. So in China, it's no problem for the disputes in connection with state-owned companies or to be arbitrated in China. So, you know, in China, the disputes in connection with marriage, adoption, and also the pure administration matters are of no arbitrability. So my question is, in Brazil, what kind of disputes are of no arbitrability?
Very good. So Carrie, please.
Sure, thanks to Natalie and Leo for the wonderful presentation regarding choice of Brazilian arbitration law. I've heard a lot of very good words concerning Brazilian arbitration law, just because parties are saying that Brazil is a jurisdiction hugely supportive of arbitration, international commercial arbitration, and other various types of arbitration. So that it's really good to hear some insiders sharing their perspectives of this particular law. Dr. Liu already shared with us a couple of other points under about Chinese arbitration law. I don't think I'm going to repeat himself here, but I just have questions posed to Natalie and Leo concerning arbitration participated by public entities. I'm not sure if I follow your comments well, but my understanding is that there are certain type of disputes taking place in Rio de Janeiro and Sao Paulo that public entities must choose Brazilian law as the applicable and use Portuguese as an arbitration language. I guess my question is that because in international negotiation, I guess it's very much up to the parties' bargaining power to choose whatever applicable they're going to use. So my question is that, what if the other part, like Chinese companies invest in Brazil, are objecting to the public entity's choice of law, even that is mandated by the statutory law? Would that force parties to go arbitration outside Brazil, or if they basically would like to go to the court to resolve the dispute? I'm just a little bit confused regarding the status after you say that public entities are kind of sort of restricted with their choice of law. So I hope Natalie and Leo can enlighten us on that, on those points.
Good questions, please, Leo.
Sure. So basically, Professor Carey, that I share your concerns and feelings towards this decision of the public administration in Brazil. But what happened is, although the 2015 amendment to the 1996 Arbitration Act did include a general authorization for the public entities to be part of arbitrations, not restricting whatsoever the law applicable to the arbitrations involving these entities. A supervenient federal decree involving, for instance, the disputes of the public administration with ports, airports, and all the models of transportation, as well as the state of Rio de Janeiro and the state of São Paulo, what they have said is, it's okay, we do authorize our public administration to be part of arbitrations in Brazil. However, we as public entities, such as at the federal level and the state levels of São Paulo and Rio de Janeiro, in order for us to accept to be part of arbitrations, we do set the requirements that the arbitrations must necessarily be decided according to Brazilian law. And of course, further on, the seat in Brazil and São Paulo and Rio de Janeiro for the respective decrees, as well as the language. So it is a condition for the state of Rio and São Paulo and for the federal administration itself on the matters involved in that specific decree that I just mentioned, to have the disputes decided by points of Brazilian law. So it's pretty much Brazil saying that it consents, Brazil as the federal government and São Paulo and Rio de Janeiro state as administration itself at the state level. They do consent to arbitration. However, the arbitration must necessarily be decided by Brazilian law with the seat and the language as previously explained.
Yeah, just let me see if I understood well. Carrie and Li Hu. In China, for example, if you have an arbitration between a state or an entity company, let's say like that, and an enterprise, you can choose, for example, Brazilian law, and the language will be in English. Could be that's possible in China?
It's possible. It's possible.
Really?
Yeah.
Great.
For example,
Right.
last year, CMAC has accepted 4 cases where the parties agreed with CMAC arbitration, but with foreign law as applicable law to the substance of the disputes. Canadian law, Italian law, English law, and Singapore law. So it's possible, no problem.
Oh, great. Nice to hear from that. It's a big difference between Brazil and China.
Yeah, I'd just like to add that a lot of disputes we're handling right now, because those involved contracts entered into, I don't know, like 10 years ago, 20 years ago, and the dispute just arose. So we see a lot of foreign laws being applied to Chinese state entities. I'm just being involved in a case involving a Chinese company and American companies. Basically, choice of law is the laws of California. But then as Chinese companies are gaining a lot more bargaining power in international transaction right now, we see an increase of choice of law, of Chinese law, of Chinese involving Chinese entities. That's just because it changed the bargaining position and commercial power. So I think in the next 10 years, or maybe in the future period, we're going to see a lot more disputes involving Chinese parties are being arbitrated under Chinese law.
Okay, so the time is running. Let's go to our third point. In some sort, we were on this point because now we face the cultural challenges concerning mediators, arbitrators, nationality, and language translation. And I raised the statement. The general principle is that harmony is most precious. I think it's a difference between China and Brazil. Yeah, and we have this kind of cultural challenges. We need to know the average time of an arbitral proceeding. For example, if an award requires a reason, it should be reasoned, and if there are some formal condition or prerequisite that an award has to fulfill under Chinese law. Questions about translations, language, the hearings that the tribunal should really held the hearings, or should leave the parties speak whatever they want and whenever, which time they want. So let's start this point. I'd like to hear from Mr. Lihu.
Okay, thank you, moderator. Thank you. In China, and take SHIMAC arbitration example, under SHIMAC arbitration rules and SHITAC arbitration rules, once the tribunal has been formed, and for international cases, the award must be made within 6 months since the formation of the tribunal. In connection domestic award, the time limit is 3 months. So generally speaking, for international cases, the whole procedure of SHITAC arbitration, CMAC arbitration will last 9 months to 12 months. And under Chinese arbitration law, the tribunal must give the word with reasons. However, if the word will be rendered in accordance with the content of the settlement agreement of the parties reached in arbitration procedure, the word can be made without reasons.
All right, so.
In China, once the word, yes, thank you. In China, once the word has been made, it's final and binding upon both parties, and no requirement for registry, court. In Chinese arbitration, the one party can be represented by Chinese lawyers or foreign lawyers, even no problem. However, in accordance with Chinese law, the foreign lawyers cannot interpret Chinese law. So in general, in international arbitrations, Chinese lawyers may cooperate with foreign lawyers. That's one point. And in our hearing of SHIMAC and SHITAC arbitrations, the tribunal will conduct our hearing freely, and the institution may just provide service, administrative service to the tribunal. And for the language, the parties may choose the language in the arbitration agreement. If the parties have such agreement, the agreement prevails. In the absence of such agreement, the language shall be Chinese. However, the institution or the tribunal may decide the other language should be applicable to the arbitration in accordance with the specific circumstances of the cases. So in the arbitration proceedings, for the documents, at the request of one party, or the arbitration tribunal may, at its own initiative, may ask the other party to provide the relevant version, the translation version, for example, in English version, Portuguese version, in the arbitration proceedings. Thank you.
Thank you. Professor Carrie Sheng.
Sure. I think Dr. Lihu has covered most important points. I just have a couple things to add. First of all, Dr. Lihu does mention that there's a limit of how much time a tribunal can use to render award after dispute started. I think that's quite unique to China. In my experiences, I do think that arbitration proceedings happen in China are a lot faster than those proceedings taking place outside China. I've been participating in arbitration proceedings in Hong Kong and other places of the world. And I would say that a commercial case normally takes at least double the times that it takes in China. Sometimes it's basically 3 times or triple the times that for those arbitration proceedings to be taking place in China. So that's one point. Chinese arbitration proceedings are fairly fast. I do think Chinese arbitrators write very good awards. These awards are written with, supported with very complicated reasoning. Those are very well written awards. Some of the best written awards I've ever seen in my experiences doing arbitration in and outside China. Another thing about our arbitral tribunal's control of the proceeding, I do think that in China, maybe I've never done arbitration in Brazil, but maybe similar as arbitration in Brazil because of the civil law training of a lot of the Chinese origin arbitrators. I do think they will actually exercise more control of the proceeding comparing to arbitrators I've encountered in common law jurisdictions, which are more likely to defer to parties to manage the process. Whether that's good or bad, I think that really that's subject to parties' choice. And also even you have arbitration proceedings taking place in China, you're afraid to choose foreign arbitrators or arbitrators that are of common law training background that are listed in those Chinese arbitration institutions. So if you prefer, like I myself do, more like party managed process and more hands-off arbitrators, I think you do have that choice as well. But in my experiences, I do think Chinese tribunals will actually manage process a little bit more than many of those arbitrators that are with a common law background. Concerning language and other type of cultural issues, I personally I haven't seen those issues arise as very problematic. I think that in China, we do have a very good supply of foreign language talents that could speak English, Chinese, and Portuguese well. I've also seen many Brazilians that are willing to learn Chinese and speak very good Chinese. We also have a lot of second generation Chinese in Brazil that are born bilingual in Chinese and Brazilian and Portuguese. So I never encountered that as a problem. And actually, when I was teaching China, I've taught many Brazilian students who come to China to learn language law. So I'm pretty sure it will have a very good supply of legal talent in the future that can actually help to communicate the parties between two sides. So not a very big problem for me.
Okay, Natalia, would you like to add a comment?
Yes, Marcio, thank you. Just to give a perspective on these issues in Brazilian law. So Brazilian law provides for a 6-month arbitration award to be rendered, but this is always set aside by the parties, which usually give the arbitrators more time to deal with the dispute. This is just a general law clause that is not usually that is not followed by the parties. Actually, in my 20 years of practicing arbitration, I've never seen a case that has been decided in 6 months after the constitution of the Arbitral Tribunal. So Professor Selma Lemes from São Paulo, one of the co-authors of the Brazilian law, she does a research every year on statistics on arbitration. And according to her research, Brazilian arbitration procedure usually takes like 1.5 years, 18 months. In reality, I believe these statistics take into account settlement agreements and arbitration procedures that have been ended by settlement agreements, because an arbitration procedure, mainly a construction or infrastructure one, may take like 3 years due to at least 2 expertise proceedings, for example. So it's not fast. It's definitive. You have a decision that may not be challenged before the judiciary courts, but it's not fast. And maybe it shouldn't be that fast as someone could expect, because due process of law, as we know, requires time and is time consuming. So regarding the next issue, in Brazil, arbitration awards must be reasoned We have a constitutional provision on Article 93, saying that all decisions must be reasoned. And this has been also included in the Brazilian arbitration law from 96. So there is no doubt that an arbitration award must be reasoned. And as Professor Carey said, I also think that Brazilian arbitrators do a good reasoning and try to make a thorough reasoning in their awards, mainly because I believe there is this idea that as it is a service that is being provided, and it's not a gracious service, it's actually it's an expensive service. Brazilian arbitrators try to provide a good award that deals with all the arguments. So this is in the law, this is provided by the Constitution, by the law, and this is also a custom in Brazilian arbitration. The other question is participation of lawyers. Well, before the judiciary, the parties must be represented by lawyers. This is well known in Brazil. Before arbitrators, Brazilian parties do not need to be represented by lawyers. They may be all by themselves with their representatives and no lawyers involved. This means that foreign lawyers may act in Brazilian arbitration proceedings, even if the Brazilian arbitration law is being applied. This is not an issue in Brazil. So regarding the control over the proceedings, mainly in hearings, I believe maybe, I don't know how Leo feels about it. I've had experience with Brazilian arbitrators who were more soft and let the proceedings and mainly the hearing go in a swift way with not a lot of intervention. In my practice, I prefer the arbitrators who exert some control over the proceedings, mainly over the hearing, because I believe this protects the parties and assures them that the arbitrators are paying attention, are taking into account everything that's happening. And this is also good on the perspective of the party to know which kind of a question, which kind of issue raises the arbitrator's attention. So I prefer arbitrators that are more controlling. And I agree with Professor Carey that some arbitrators from common law background usually are more soft in this way. And finally, regarding the language, I really hope we have more Chinese-speaking practitioners. I'm not one myself, but for example, I was checking that we don't have a lot of sworn translators in Chinese here in Brazil. For example, in Rio de Janeiro, we just have one sworn translator. In São Paulo, we have 8 sworn translators, so this is not a lot. I really believe that in the future, with all these movement to have more Chinese-Brazilian economic relationship, we're going to have more people speaking Chinese, and hopefully this is not going to be an issue anymore. So these are my initial comments. Thanks, Marcio. I don't know if Leo wants to add on.
Please feel free, Leo.
Sure, I'll be very brief. I agree basically with everything Natalia said. What I wanted to add here is it relates to the average time that a case, an arbitration takes in Brazil. I would say, at least in my practice, I agree with Natalia. I've never seen any case that has been decided within 6 months or even a year. It's really very rare. I would say that as an average. If the case requires a very narrow expert evidence or no expert evidence at all, I would say that 2 years is a reasonable average, at least based on my experience. However, if the case requires further expert evidence, especially in infrastructure and construction disputes, this average goes over 3 to 4 years at least. Of course, this is here an average, and we can see enforce proceedings that are decided within this time frame of 3 years. But I've seen cases decided over 4, 5, even 6 years because of the complexity of the expert evidence being assessed by the tribunal. That's what I wanted to add to the discussion.
Thank you, Leo. It's a very good point. When actors and arbitrators, in my case, sometimes we reach 4 or 5 years, but because it's important for that, we have some experts that these 4 or 6 months for the first round, and after more 6 months, or have 1 year, 2 years just for the experts. All right, so the time is running. Let's go to our 4th point, and it will be enforceability of the arbitral award in China and Brazil. Let's try to understand if these 2 countries fully adopted the New York Convention of 1958, if there are some steps necessary to recognition and enforcement to form arbitral awards, if there are some numbers regarding the percentage of awards that are brought for recognition in China, in Brazil, and that are indeed recognized. So it's a very important point, as I mentioned in the beginning, to know at the end of the arbitration, you have an award, and if its award will be really recognized and enforceable in, doesn't matter in what country. I would like to start with Mr. Lihu, please.
Thank you, Professor. Yes, China has ratified the New York Convention in 1986, and the New York Convention has come into force in China since next year, 1987. When access to New York Convention, China has made 2 reservations: the commercial reservation and the reservation of reciprocity. For the enforcement of the foreign arbitration award in mainland China, so the enforcement is made in accordance with the New York Convention. In China, the competent court for enforcement is intermediate people's court. You know, we have 4 levels of people's court: lower court, intermediate court, high court, and the Supreme Court. So IPC is a competent court for enforcement at a place where the respondent domiciles or its property is located. The time limit for the winning party to apply for enforcement, if both parties or legal entities or organizations, the time limit is 6 months after the party receives the final word. If one of the parties is individual, the time limit is 1 year. After acceptance by the court, after the court receives application for enforcement, and the court will issue the notice for enforcement to the losing party. The respondent, losing party, will have 15 days to make its argument that the award should not be enforced because it's involved with the statutory grounds for non-enforcement. So after examination by the court will issue its decision within 2 months after the court has received the application for enforcement. So it's a general procedure. To my best knowledge, you know, for the enforcement of foreign arbitration award in China, most of the words has been enforced smoothly. In generally speaking, Chinese courts can apply the New York Convention rightly. But you know, about 6 years ago, I know one SCC award was refused enforcement in China. So because one of the issues has been finally decided by Chinese courts. However, SCC tribunal in the arbitration proceedings and re-examined such issue and has made its final decision again in the final word. So the Chinese court thinks that the SEC award has violated public policy in China, and decides to partially refuse enforcement of the SEC award. Thank you.
Thank you very much. Professor Carrie, would you like to add a comment?
Sure. I think Dr. Li Hu, again, has given us a very good, very thorough overview. Just a couple of things to add. First of all, I think the general trend in China is that it has become a lot easier to enforce foreign arbitral awards. So I think generally parties don't have to be concerned with the enforceability of foreign awards in China. The courts are generally very supportive. And there is actually a mandate from the Supreme Court that for foreign awards that hasn't been enforced in China, there's actually a additional review process. Only if the intermediate people's courts decided to set aside award, then there's additional review process, which normally takes about 6 months to a year for the Supreme Court to come up with a decision whether to affirm this set aside award or reject the set aside award. So there's additional protection of arbitral awards in China, which also demonstrated the general supportive attitudes of arbitration enforceability. We actually published a paper last year that studied 98 refutes to recognition awards between 1995 and 2020 and 2005, studying the decision rationale. There were only like about 98 awards that wasn't enforced, that were set aside initially by intermediate people's courts, but then half of them were reversed by the Supreme Court by this internal review procedure, which provided additional protection for parties. Another thing I wanted to mention is that I think many arbitration parties are concerned with interim measures being enforced and not being enforced in different countries. I'm not sure of the status in Brazil. Previously, there were some difficulties with enforcing interim measures, which are measures and orders that are given arbitral tribunals in the middle of the process, usually involving asset preservation, some form of injunction. And actually, China and Hong Kong, mainland China and Hong Kong, has entered into agreement, I think last year, concerning enforcing interim measures. So if it's an arbitral proceeding conducted in Hong Kong, and then there's interim measure that can actually be recognized, enforced by Chinese courts immediately. There are already a couple of case law. So I think recognition of interim measures as part of the award is also improving in China. Those are my general observations.
Leo, now it's your time, please, to compare from our side. You're muted.
My pleasure, yes. So before actually entering into the subject of the New York Convention, just to provide Professor Carey and Mr. Liu with an overview of how the Brazilian system works in what concerns recognition and enforcement of foreign arbitral awards. Allow me to explain that until 2004, the Brazilian Supreme Court had exclusive jurisdiction to recognize foreign arbitral awards and foreign judgments, as well as letter rogatory. There's been a change in the Constitution, shifting this exclusive jurisdiction to the Brazilian Superior Court of Justice. We call it the SCJ, and which is our Supreme Court for federal law issues. It plays the same role of the Supreme Court, but in what concerns federal law. So it shifted the exclusive jurisdiction to the SCJ, and since January 2005, the exclusive jurisdiction to decide these issues lies with the SCJ. Once a decision on a foreign arbitral award is recognized by the SCJ, it must be enforced at the trial level before a federal court. This is a requirement of the Brazilian Constitution. So once the award is recognized in the capital of Brasilia by the SCJ, the interested party must go before a federal court at the trial level of whatever it wants to enforce the award and ask for that specific federal court for support in terms of enforcement. So with that in mind, I would like to clarify, and that would be sometimes it gives people some sort of surprise of how that happened in Brazil. But let's say that Brazil enacted its the Arbitration Act in 1996. At that time, Brazil had not ratified the New York Convention. It only happened in 2002. But at that time, there was a lot of resistance from the executive branch and the legislative branch. So the draftsman of the bill, which eventually became the Brazilian Arbitration Act of 1996, they incorporated in the bill the main framework of the New York Convention. So Brazil, we could say that it pretty much became a New York Convention follower, so to speak, before actually being a part of the convention, simply because the structure of the convention was incorporated in the Brazilian Arbitration Act of 1996, which contained an interesting provision saying that this is the law applicable to this matter. However, whenever there's a treaty, because the draftsman of the bill knew that the New York Convention would eventually be ratified by Brazil, whenever we have a treaty dealing with this issue, the treaty will apply. So fast forward to 2002, Brazil ratifies the New York Convention. And then fast forward 3 more years to 2005, and the STJ started to decide and had exclusive jurisdiction to decide applications for the recognition of foreign arbitral awards. So what happened is, since 2005, Brazil, although we already had the New York Convention as part of our legal system, and with an express provision of the Brazilian Arbitration Act saying that the treaty would apply whenever ratified by Brazil, the STJ has been pretty much applying, with few exceptions, but very few. The court has been applying the Brazilian Arbitration Act provisions instead of the New York Convention provisions. And although they're very similar, pretty much like I said, the Brazilian Arbitration Act incorporated the framework of the New York Convention, and it's really, really similar and almost to the same level. But the problem with that is, whenever the STJ is deciding the application for the recognition of foreign arbitral awards, instead of looking to the New York Convention and to and how foreigners do apply this convention worldwide, Brazil is pretty much looking at its local law, the Brazilian Arbitration Act, and therefore it misses the opportunity of taking or learning from the practice of other countries in order to bring it to Brazil. And it happens until this day. And like I said, there are a few exceptions to this unfortunate way of interpreting the law, but still the majority of the cases decided by the STJ in what concerns recognition of foreign arbitral awards, they do refer to the Brazilian Arbitration Act and not the New York Convention. I'm sure Marcia will touch upon it, but I'll just go ahead and advance this topic. In terms of numbers, Professor Nadia de Araújo, who is distinguished professor of private international law in Brazil and arbitrator as well, she keeps tabs on the numbers of cases that have been applied, of recognition cases that have been applied before the STJ. And she generously shared this information with me recently. So from 2005 until today, we've had 118 cases of applications for the recognition of foreign arbitral awards in Brazil, and roughly 10% have been denied recognition. So on the other hand, 90% of the cases were recognized by the STJ, which is a good record, of course. And generally, the decisions are quite good. It's very clear to the STJ that they do not delve into the merits whatsoever of the decision being incorporated or being recognized in Brazil. They are very careful as to that. Of course, there are the main defenses of public policy and sovereignty, which are basically the main defenses for the parties to claim as defense before the STJ. And jumping forward to the question whether or not Brazil has fully adopted the New York Convention, my first answer would be partially yes, with the caveat that we still have the Brazilian Arbitration Act, which is a sort of a copy of the New York Convention being applied. But there's one major difference, and this is where I say that Brazil has not been applying the New York Convention to the full extent of it, is that, as we all know, the defense of public policy refers to the international public policy of the country in its relation to the other countries in the globe. However, the Brazilian STJ has been interpreting the public policy defense looking only for the national or domestic or local public policy of Brazil. And that can play a very relevant role in terms of recognition for what actually represents a local parochial defense of public policy, or what would constitute an international public policy under the spirit of the New York Convention. And this, Brazil still has to develop a lot its case law on the matter. But once again, I believe this is a matter of time. The STJ has growingly been paying more attention to international treaties and the application of these instruments in Brazil. And hopefully we will see this correction, under my view, this correction on the application of the New York Convention shortly in the future. Thank you.
Great comparison, Leo. Let's hear from Natalia if she has something to say.
Yes, I'm going to be really quick because Leo is an expert of the subject. He wrote a book on this. So I'm just going to add that I believe that Brazil should really, and SCJ, that's a mission from SCJ actually, should really try to have a more international spirit towards the recognition and enforcement. So this means applying the New York Convention, mentioning the New York Convention, and having in mind that it's an international public policy defense. Whenever you raise the public policy defense, it has to be the international one. And the standards of analyzing an award must actually try to be the most international possible. And why I'm saying that? Because we had a very contentious issue before the SCJ, which was the Abengoa case. It's one of the 10% of denial of recognition. It's a very a famous case in the world. A lot of clients ask, so how is the SCJ dealing with the recognition of awards? And we say, oh, it's usually really good. Brazilian law is similar to New York Convention. The SCJ still refers to Brazilian law, but as it's similar, it's not a very big issue. But there was the Abengoa case. Well, Leo was also one of the lawyers of the case, so maybe he didn't mention it because of that. But the Abengoa case, I believe that if the SCJ had an international thought, because the award was rendered in New York and had been through a set-aside procedure in New York, and the federal court in New York had said, no, there was no lack of impartiality on the side of the president of the Arbitral Tribunal. This was the main matter. Actually, the main issue at stake was the president of the Arbitral Tribunal partial? And the seat of the arbitration, the courts of the seat of the arbitration have said that no, he was not partial. The arbitration was fair and correct. So we are going to uphold this arbitration award. The international party came to Brazil to recognize this award, and it had to deal with an SCJ interpreting and dealing and construing the impartiality principle in a very parochial and provincial way, if I may say so. It's actually, I know that I'm being critical, but I think this critic must be done because this case is very famous and everybody refers to it as if Brazil had this parochial view of impartiality principle, and I do not believe so. And so I fully endorse what Leo just said, and I really hope that the SCJ gets this international spirit, either applying the New York Convention, either seeing the awards whenever it feels that it should deny recognition, seeing the awards with this international view that I believe would be a very good solution. For example, the Abengoa case, which would have a different outcome if they had seen it with this international view. So sorry if I was long. Thank you, Marcio.
Not for that, it was very, very good. We are really comparing Chinese and Brazilian law, and more than that, perspectives, practices. So we arrive at the end of our panel. It was a wonderful panel. I'd like to thank you, everyone, all of you from California at 4 a.m., Carrie Shang in the morning, Mr. Liu in China, almost midnight, us here starting our day. So it's a really international panel. I'd like to thank you, Professor Evandro Carvalho as well, that organized all these seminars, the 4th edition. He's the coordinator of our center, Brazil and China Center of our law school. And I'd like also to announce that we are producing a book together, Arbitration Brazil and China, on the Brazil-China law series. Me, Professor Evandro Carvalho, and Mr. Liu, that will be published next year. So I think the beginning of the next year, we'll have some chapters from Chinese authors and Brazilian authors showing how it works in each country, each branch of the law. And for finish, I'd like just to share with you a thought, like an answer that I ask always when I finish my classes, if am I the same person in the beginning or even in the after tribunal? And the answer today is no, I'm not the same one, because I have here a very rich discussion, and you could understand more with this rich debate, the trade and dispute resolutions between China and Brazil. Thank you very much, everyone. Have a nice day. Hoping to see you soon. Thanks a lot. Bye-bye.
Thank you, Professor. Thank you.
Thanks
It's nice to meet you, Carrie, once again online. Thank you, my colleague.
Thanks, everyone. Great event. Thank you.
Thank you.
Thank you.
Bye-bye.